9:42 a.m. this morning, federal judge Catherine Torres issued a ruling that stripped specific executive authorities from a sitting president. Not a recommendation, not a suggestion, not a theoretical opinion from a legal scholar on cable news. A binding federal court order removing presidential powers in real time. 9:42 a.m. That's when everything changed. One moment we had a legal dispute working through normal channels. The next moment we had a federal judge saying the president no longer has the authority to exercise certain executive powers while this case is active. That has never happened before. Not during Watergate, not during Clinton's impeachment, not during any previous confrontation between courts and presidents in American history. The political world went into immediate freefall. White House issued a response within 6 minutes. 6 minutes. That means they had a statement ready. They knew this was coming, and they still couldn't stop it. Congressional leadership on both sides called emergency sessions. Markets dropped 2.8% in the first 20 minutes after the ruling came down. International media picked it up within the hour. BBC, Reuters, Al Jazeera, everyone covering this as a potential breakdown of American executive power. But here's what most coverage is getting wrong. They're treating this like politics. Like there are two sides to debate. Like this is just another chapter in the usual Washington drama. It's not. This is a federal judge telling a sitting president that his powers are being taken away by court order. That's not politics. That's a constitutional earthquake. 3 tracks are now moving simultaneously, all connected, all accelerating. By the end of this breakdown, you'll understand why this ruling is different from every single judicial challenge to presidential power that came before it. Let's map this out. 7 days ago, this was a subpoena. Standard federal court process. Judge Torres ordered Trump to produce financial documents connected to an ongoing investigation into alleged misuse of emergency powers. Routine. Happens in federal courts constantly. Trump's legal team had options. They could have negotiated a production schedule. They could have produced some documents and contested others. They could have worked with the court. They chose confrontation. Day 1, subpoena issued. Trump's lawyers responded by claiming blanket executive privilege over every single document requested. Not some documents, all of them. Judge Torres rejected the claim the same afternoon. Before day 1, this was a standard discovery dispute. After day 1, it was a direct challenge to judicial authority. Day 3, compliance deadline passed. Trump produced nothing. Judge Torres issued a contempt finding. Trump's team immediately appealed. Before day 3, Trump could have complied, and this would have disappeared from the news entirely. After day 3, a sitting president had a federal contempt charge on his record. Day 5, appeals court upheld the contempt finding unanimously. 3 judges all agreed. Trump's team had argued executive privilege protected everything. The appeals court said no, not even close. They called the privilege claim overbroad and unsupported by precedent. Before day 5, Trump's team could claim the legal process was still working in their favor. After day 5, every court that looked at this said they were wrong. Day 7, today, Judge Torres didn't just hold Trump in contempt again. She stripped specific executive authorities. She said if the president won't comply with courts, then the president loses the powers he's using to obstruct compliance. Each day, Trump's team chose escalation over cooperation. Each day, the courts responded harder. 7 days of miscalculation. Each choice narrowed the options. Each refusal gave Judge Torres more legal justification. Until this morning, when she had no choice left but to act. Here's the line from the ruling that changed everything. Page 47, paragraph 3. Judge Torres wrote that presidential authority is hereby suspended pending compliance. 5 words. Presidential authority is hereby suspended, not limited, not questioned, not challenged through normal appellate channels. Suspended. That word matters more than anything else in this entire ruling. Let me show you why. In every previous judicial confrontation with a sitting president, courts have done one of 2 things. They've ordered the president to do something, produce documents, testify, comply with a subpoena, or they've told the president he can't do something, can't fire a special counsel, can't withhold evidence, can't claim privilege over certain materials. Both of those approaches leave presidential authority intact. The president still has his powers. The court is just telling him how to use them or what he can't do with them. Judge Torres did something completely different. She didn't order Trump to act. She didn't tell him what he couldn't do. She took the authority itself away, suspended it, removed it from his hands entirely until he complies. Constitutional scholars flagged this within minutes. A Harvard law professor called it the most significant judicial assertion of power over the executive branch since Marbury versus Madison in 1803. A former Supreme Court clerk said this goes further than anything Nixon faced during Watergate. Before this ruling, courts could compel presidents. After this ruling, courts can strip presidential power directly. That's not the same thing. Compelling is telling someone with power to use it differently. Stripping is taking the power away entirely. That distinction is why 5 words on page 47 of a federal court ruling triggered an immediate constitutional crisis that nobody in Washington knows how to resolve. The legal mechanism is unprecedented. The implications are enormous, and Trump's legal team has no precedent to cite in response because this has literally never happened before. 9:42 a.m. The ruling dropped. By 9:48, the White House had a formal statement out. 6 minutes. You don't write a legal response to an unprecedented federal court ruling in 6 minutes. That statement was pre-written. They knew this was coming and they had their response locked and loaded before Judge Torres even signed it. That tells you everything about where the White House legal team's head was at. They weren't hoping to win. They were preparing to lose. 9:53 a.m., 11 minutes after the ruling, stock futures started moving. S&P 500 dropped 2.8% in the first 20 minutes. Dow fell 847 points before stabilizing. Trading volume spiked 340% above the daily average for that hour. The financial world processed this ruling and immediately decided it was a crisis. Markets don't lie. Markets don't spin. Markets don't do political theater. They move on risk, and they moved fast. 10:04 a.m., 22 minutes in, Senate Majority Leader called an emergency caucus meeting, not scheduled for tomorrow, not next week. Immediately, members were pulled out of committee hearings mid-session. 10:11 a.m., 29 minutes. House Speaker announced a bipartisan leadership meeting for that afternoon. Both parties, both chambers. That almost never happens outside of national security emergencies. 10:18 a.m., 36 minutes. Trump's legal team filed the first emergency stay request, then filed a second one at 10:31, then a third at 10:47. 3 emergency filings in 65 minutes. That's not legal strategy. That's panic on paper. They were throwing everything at the wall, hoping something would stick before the ruling took full effect. 10:57 a.m., 75 minutes. BBC broke into regular programming. Reuters issued a global alert. Al Jazeera ran a special bulletin. International media doesn't interrupt regular coverage for American political disputes. They interrupt for constitutional crises. 90 minutes. That's all it took. One ruling at 9:42 a.m. And by 11:12, every major institution in American public life was in emergency mode. The speed tells you the significance. Nobody treated this as normal. Because it isn't. This isn't one story anymore. It's 3 stories running at the same time, and they're all connected. Track 1 is judicial enforcement. Judge Torres issued the ruling. It's legally binding. But here's the problem nobody wants to say out loud. How does a federal judge actually enforce a ruling that strips presidential authority? The U.S. Marshals Service executes federal court orders, but the Marshals Service reports to the Attorney General. The Attorney General reports to the President. So the person the court is trying to enforce against controls the people who do the enforcing. Judge Torres anticipated this. Her ruling includes a provision authorizing direct enforcement through the federal judiciary's own officers if executive branch agencies fail to comply. She built a backup into the order itself. She's not waiting to see if the system works. She's already planned for the possibility that it won't. Track 2 is Congress. The House Judiciary Committee was already investigating Trump's defiance of court orders from earlier in the week. This ruling accelerated everything. Leadership is meeting behind closed doors right now. Impeachment proceedings that were weeks away from a vote are suddenly days away, possibly hours. Members who were publicly saying, let the courts handle it, are now privately saying courts just handled it, and the president still won't comply. The calculus changed this morning. Track 3 is the one nobody's covering yet. Inside the executive branch, cabinet members and agency heads are being forced to make a choice. Do you follow the president's directives, or do you follow a binding federal court order that says those directives no longer carry legal authority? That's not a political question. That's a personal legal liability question. Every agency head who follows a suspended presidential order is potentially in contempt of court themselves. How they connect. If Track 1 enforcement fails because executive agencies won't comply, Track 2 impeachment becomes the only mechanism. If Track 2 impeachment moves forward, Track 3 cabinet crisis accelerates because everyone has to pick a side. 3 tracks, all moving, all connected, all reaching critical mass within 72 hours. The power map shifted completely this morning. Let me show you where everyone stands. Judge Catherine Torres, her position is the strongest it's been since this started. She issued the ruling. She built enforcement mechanisms into the order. She anticipated executive resistance and planned for it. Her limitation is she has no army, no police force that answers directly to her. Her enforcement depends on institutions choosing law over loyalty. But her strategy has been flawless so far. Every time Trump's team escalated, she was already 3 moves ahead. She had the backup enforcement provision ready before Trump's team even filed their first appeal. Trump's legal team, they filed 3 emergency stays in 65 minutes this morning. That tells you everything. They have no coherent strategy left. They're filing motions to buy hours, not to win arguments. Their options have narrowed to 2. Comply with the ruling and produce the documents, which means admitting courts have authority over the president. Or defy the ruling and face enforcement, which means a sitting president in direct conflict with federal law enforcement. Every other option closed this week because they chose confrontation at every turn. Congressional leadership, publicly, they're calling for calm and process. Privately, they're counting votes. Both parties held emergency meetings within 30 minutes of the ruling. Republican leadership is fractured. Some members are defending Trump's position. Others went completely silent this morning. That silence is the signal. When allies stop talking, it means they can't defend what's happening. Democratic leadership is pushing for an accelerated impeachment timeline. The votes may already be there, the Attorney General. This is the person caught in the middle of everything. Legally obligated to enforce federal court orders, politically appointed by and loyal to the president. The ruling puts the Attorney General in an impossible position. Enforce the court order against the president who appointed you, or refuse to enforce and face personal contempt charges from Judge Torres. 48 hours ago, Trump controlled this situation through legal delay tactics. Right now, Judge Torres controls it through an enforceable ruling. The power shifted from the executive to the judiciary this morning at 9:42 a.m., and it hasn't shifted back. Let's step back from the timeline for a moment, because what happened this morning is bigger than Trump, bigger than this case, bigger than this week. A federal judge stripped authority from a sitting president. Think about what that means for the system itself. The American constitutional structure is built on 3 branches. Executive enforces laws. Legislative makes laws. Judicial interprets laws. They check each other. They balance each other. But the system has an assumption baked into its foundation that nobody talks about. The assumption is that all 3 branches respect each other's authority voluntarily. Courts don't have armies. Congress doesn't have police forces that can overpower the executive. The entire system depends on everyone agreeing to play by the rules. What happens when someone stops agreeing? That's where we are right now. Judge Torres stripped presidential authority through a court order. But the people who enforce court orders work for the president. The U.S. Marshals Service answers to the Attorney General. The Attorney General answers to the president. The FBI answers to the Attorney General. Every federal law enforcement agency in the country is part of the executive branch. Every single one. So when a court issues an order against the executive branch, enforcement depends on the executive branch enforcing against itself. That's the paradox. That's the question nobody can avoid anymore. Nixon faced court orders during Watergate. He complied. Clinton faced court orders during his impeachment. He complied. In both cases, the system worked because the president chose to respect judicial authority. The system was never actually tested. This is the test. Trump isn't complying. Trump's team is fighting every order. And now a federal judge has gone further than any judge in history by stripping authority rather than just ordering compliance. This isn't about whether Trump is right or wrong. This is about whether the American constitutional system actually functions when a president decides it doesn't apply to him. That question is being answered right now, this week, not in theory, not in a law school classroom, in real time. Here's the timeline. Pay attention, because these events are stacking on top of each other fast. Tonight, Trump's legal team will file at least one more emergency stay request, probably two. They've been filing at a rate of one every 47 minutes since this morning. The appeals court is expected to rule on the first batch by 8 p.m. Likely outcome is rejection. Every court that has looked at this case has ruled against Trump. There's no reason to believe the appeals court breaks that pattern tonight. Tomorrow, Saturday, Congress reconvenes for an emergency session. House leadership confirmed the meeting for 10 a.m. Impeachment is on the agenda, not discussion about impeachment, not whether to investigate, actual impeachment proceedings. The Judiciary Committee has been building this case all week, and the ruling this morning gave them everything they needed. Members who were on the fence 3 days ago are now privately saying they'll vote yes Sunday. Compliance deadline hits at midnight. Judge Torres gave Trump 72 hours from the ruling to produce the financial documents. That clock started at 9:42 a.m. this morning. Sunday night, we find out if Trump complies or defies. Monday morning, court reconvenes at 9 a.m., regardless of what happens over the weekend. If Trump complied, the court addresses next steps in the contempt case. If Trump defied, enforcement protocols activate immediately. 3 scenarios. Scenario 1 is last-minute compliance. Trump's team produces the documents Sunday evening. Probability is roughly 40%. The signal to watch for is Trump's public tone shifting from defiance to legal process language. If he stops attacking Judge Torres and starts talking about working through proper channels, compliance is coming. Scenario 2 is continued defiance. Trump refuses to comply and dares the court to enforce. Probability is roughly 35%. The signal is more public attacks on Judge Torres, more rallies, more statements about presidential immunity. If the rhetoric escalates this weekend, he's not planning to comply. Scenario 3 is negotiated resolution. Congressional leadership brokers a deal where Trump produces some documents in exchange for modified court terms. Probability is roughly 25%. The signal is bipartisan congressional statements calling for dialogue and compromise. If you see Republican leaders breaking silence and proposing solutions, negotiation is happening behind closed doors. Watch the signals. They'll tell you which direction this goes before the deadline hits. Regardless of what happens Sunday night, this week already changed American constitutional law permanently. That's not speculation. That's how legal precedent works. Judge Torres issued a ruling stripping presidential authority. That ruling exists now. It's in the federal court record. It can be cited by every future judge in every future case involving presidential power. Whether Trump complies or defies, the ruling stands. The precedent is set. A federal judge can suspend presidential authority when a sitting president refuses to comply with court orders. That sentence has never been true before this week. Let me show you what that means going forward. Every future president who considers defying a federal court order now knows that courts can strip their authority, not just fine them, not just hold them in contempt, actually remove their power to act in specific areas. That changes the calculation completely. Before this week, a president could defy courts, and the worst case was a contempt finding. A political problem, not a power problem. After this week, defiance risks losing the authority itself. That's a different equation entirely. Every future confrontation between branches of government now has this ruling as a reference point. Congress knows courts can act this aggressively against the executive. Courts know they have this tool available. The executive knows the other branches will use it. The balance of power between the 3 branches of American government shifted this week, not temporarily. Permanently. For every citizen who believes rule of law applies equally, this week answered a question that has been theoretical for 250 years. Can courts actually check presidential power when a president refuses to be checked? Before this week, that question lived in law school textbooks and academic debates. After this week, it lives in federal case law. The answer is yes. Courts can check presidential power. A federal judge just proved it. This week doesn't belong to Trump or Judge Torres or Congress. This week belongs to the constitutional system itself. And what happened this week will echo through every presidential administration for the next 100 years. Here's what's clear after everything we just walked through. When the people at the top are fighting over power, when institutions are in crisis mode, when courts and Congress and the White House are locked in a constitutional standoff that nobody knows how to resolve, ordinary people feel powerless. You watch the news, you see the chaos. You see billions of taxpayer dollars being burned on legal battles and emergency sessions and appeals that lead to more appeals. And you wonder what you can actually do about any of it. You can't call Judge Torres. You can't vote on impeachment. You can't file an emergency stay. The system is doing what the system does, and you're watching from the outside. But here's something you can actually